Hello, beautiful moms and entrepreneurs. My name is Charisse Walker, and I'm your host of the Unbreakable Mompreneurs podcast. This is a place where we come together to learn, grow, and inspire. So sit back, relax, and let's get started. My name is Charisse Walker, and today I'm here with Kelli Jones, and I am actually so excited. I was just telling her how excited because purely for selfish reasons, I can totally apply what she's going to talk to us about. And so I hope that if you are thinking about writing a book, or if you have something you'd like to trademark or anything like that, Kelli is your woman. She is a trademark lawyer for entrepreneurs. And so without further ado, Kelli, why don't you introduce yourself?
Yeah, thanks so much for having me. I am a lawyer for business owners. I help them with all kinds of legally protecting their business. So trademarks, contracts, copyright, business, startup strategy and things like that. And I've had my own practice for this summer will be 4 years. And before that, I worked going to court every day, different type of law. So it's been really awesome getting to work with business owners over the last 4 years.
That's great. And the fact that you're doing it on your own, that's even better, right?
Yes.
Okay, so why is it important to get a trademark?
Yeah, so a trademark is what you would get if you want to get ownership over your brand in connection with whatever goods or services you're selling. So that's really how you get ownership over the name. A lot of people think oh, I'm going to start a business, so I'm going to file my LLC, and that's how I protect my name. But that's not actually the case. The LLC, what you're doing with that, whether it's an LLC or corporation or, whatever type of business entity, that is really to protect your personal assets like your house, car, bank accounts, investment accounts. Should anything go wrong in your business, like with either creditors or you get sued or something like that, but it has nothing to do with the name. Yes, you're choosing a name, but you're not actually getting ownership over that name by choosing it. It's just what happens to be available in your state. So a trademark is really where you're getting ownership over that name. And so it could be like the name of your business. Some people, maybe they do business as their legal name. So maybe that's not something that's like a high priority to trademark. So maybe it's something else like a course name, a podcast name, a program name, product line name, something like that. Basically something that you use to identify your goods and services. It can also be your logo or a tagline, something like that. And then, so as far as getting ownership over it, so you don't have blanket ownership for, absolutely everything, but you have it for the types of goods and services that you're doing.
Great. So how does that differ from copyright?
Yes. So when you think trademarks, that's kind of like the brand, the overall name of some piece of your brand. And then copyright is really like the creation side of it. So it can be any type of creation, whether it's like a picture, a blog, a book, a video, anything that you're creating, and then you're essentially publishing somewhere. So, you hit publish on the blog post, you're publishing a book, putting out a video online, anything like that. So once you do that, you as the creator own the copyright right away. As soon as you do that, even if you don't file anything. Now you can file something, and then you get additional protections, but basically you still hold the copyright to it as soon as you do it. So trademark is more for the brand side, the overall brand, and then copyright is the actual creations.
Okay. That makes sense. And I was looking because my book, I was thinking, well, do I need to copyright it? Do I not need to copyright it? And then I thought, okay, well, I started researching and exactly that, but it's just for more protection. So how long does it take to get a trademark? Because I heard it's pretty long.
Yes. So it's a federal government, so it's getting slower and slower. So right now they're averaging about 15 months. That's what they say. In my experience, most of my clients, it takes a little bit longer than that. Some do take the 15 months, but usually it goes a little bit longer. And most of that is, so when you apply, once you apply, you wait about 9 to 10 months for it to get assigned to someone in the trademark office to review it. So that's really the bulk of the waiting time is before it's even gotten assigned to someone, just because they have such a backlog.
You'd think that they'd hire more people,
Yeah, and they have, and then they've still not increased their time. So I'm what's going on over there?
So do you think it's just there's more and more people filing, or they just have a really slow, archaic system? I mean, really, why isn't with AI, why does it take so long? But anyway.
Yeah, I think it's definitely a combination of both things. I think also like as they're hiring, the examiners are newer, so they're not going as quick as maybe people that have been there longer would go. And then also I know definitely in 2020 there was like a surge in applications. I think also from people, everything with the pandemic created a lot of additional business owners, so just a lot more trademarks being filed. So we saw a surge then, and it's kind of like plateaued now as far as like filings go, but still, there's still more than there used to be in, decades ago. So yeah, I think it's a combination of things.
Okay, that makes sense. So what does it mean to go from renting your brand to owning a trademark?
Yeah, so basically that's what I mean by before you have the trademark, you're kind of um you're kind of at risk because once you start using something, essentially you have these unregistered rights to it because you've been out there using it, for whatever goods or services you're using it with. But if you only rely on those unregistered rights, it's kind of like you're just renting it because you might not essentially be able to keep it. You might be forced to either rebrand or have to try to fight for your brand. And that's just because if you don't file, technically the law is whoever's using it first. But when it comes to down to it, really, it's kind of like who files first, because if someone else files before you and you have not filed, and not just even for something exactly the same, but even something kind of similar, someone else files, you don't have a trademark, they can send you cease and desist. If you try to apply, yours is probably going to get denied because of theirs. So you could potentially fight it saying like, I've been using it longer. But what likely is going to happen at the end of it is you'll only be able to use it within a small geographical area. Like the original Burger King, they can only use theirs within a 20-mile radius in Illinois. It's not the big chain we see today. That's because someone else got the federal trademark
Oh my
after
gosh.
they opened. So, and to get to that point of only being able to use it in a small geographical area, it's basically like a court proceeding. So it's going to take usually a lot of time, a lot of money, like
Yeah.
hundreds of thousands. So that's why essentially like for a lot of, especially smaller businesses, if you haven't filed first and someone else beats you to it, usually the like cheaper cost of, the cheaper option is to rebrand. So that's really why then you're kind of stuck like renting it, because you can be kicked out of it if someone else is there and you don't have the money to fight it.
It's crazy. Tell me another good story. I never knew about the Burger King.
I know, that's one of my favorite ones.
That is, I honestly didn't know that. That's crazy.
Yeah.
So if I went, okay, all you entrepreneurs, go and find something that's taking off if it's not trademarked. But you don't know because obviously there's a 15-month backlog. So somebody could have already, because isn't it whoever files first has the rights?
So whoever files first will be first in line to be reviewed by the trademark office. But you have to have like a good faith basis for believing that you're going to be, using this as a brand and that you have the rights to use it. So you're not going in with like potential infringement purposes and things like that. So yeah, you kind of have like you want to be the first to file, and that's kind of also why it's about 50-50 on the amount of the number, like when someone files, whether either before they launch or after they've already launched. Just because a lot of businesses will file the application, just get it in before they've, especially if, they're creating products, something that takes a while, like it's easier to just file the application, start that long waiting process, and then, come to market during that waiting period.
Wow. So how long does it usually take I mean, how much does it usually take to file?
Like how much money?
Yeah, sorry.
So the cost, so like for when you're hiring a lawyer, it's about, usually I'd say like about 3,000, maybe a little more. And that is because basically the first thing that we do before actually filing is we do a full search to assess the risk level of your mark. And this is a very in-depth search. You can do a basic free search on the USPTO website, and I recommend that for like everyone, even if you're just coming up with a name for like a program or something or an event. Just it's a good way to like identify any like major red flags, but it doesn't catch a lot. So that's why we do the more in-depth search, uses algorithms and everything to really figure out anything that is too similar in name. So like in sound, appearance, meaning, impression, and then also too similar in goods or services. So we look at that. That way we don't waste time and money filing for something that doesn't really have a good chance of actually getting through, because you'd rather know that before you file than find that out 10 months down the line when you've like invested more money and time into building the brand. So that's really a big portion of it. And then it also goes by filing fees. So they charge their filing fees $250 per class. So all goods and services are broken down into 45 classes. So then that can just depend on like a lot of like educational coaching podcasts, like that's all in one class. But then if you were to have like, let's say you wanted to sell some type of apparel, that's a different class. Or like a lot of like done for you services, like if you were doing, you know, social media management or some marketing or something, that's a different class. So that sometimes the fees can add up in that also.
Wow. And that's very creative, because the more classes you create, the more people have to pay for it. So the more expensive it gets for you and the more money they make. So
Yeah.
smart. Very smart.
Yeah.
What are some other things that somebody should know? Like when they start to think, hey, I'm going to trademark my name.
Yeah. So usually I ask 3 questions. So one is, do you have something in your brand that you want to use for the foreseeable future? So it's not just something temporary, you know, an event that you might run once, you know, then maybe that's not something you want to trademark. It's something that you think you want to keep. And then after that, would you be upset if someone else popped up with the same or similar brand? And usually I say you kind of should be upset about that a little bit, because the whole point of a trademark is you don't want people to be confused between your brand and someone else's brand. So if someone else pops up with something similar and they're doing something similar, then that potentially causes confusion. You know, if people are searching online or come on them when, you know, they thought it might have been your brand or something like that. And then 3, like, would you be upset if you were forced to rebrand because of this other person that popped up? And then if the answer is yes to all of those, then that's when it's time to think about like, okay, maybe I should look into trademarking.
Okay. So a title of a book, does that need to be trademarked or?
So books are interesting in that you cannot trademark a title of a book. So a lot of people, you know, there's tons of books with the same name out there. So you can't trademark the title of it, but you can trademark a series of books. So like Twilight, the series, or like Harry Potter, so you can trademark titles of series, but not individual books.
Interesting. Good to know.
Yeah.
What else? What else do I not know anything about? Because I'm learning.
Yes, yes. Um, let's see. Just mostly that, you know, the more proactive you are, the better. Just because, again, really that like if you wait, then you might have to either rebrand or pay tons of more money in later on. And so that's kind of the biggest thing. And that really goes with all of the legal. I pretty much always say like every part of the legal is kind of just stacking different legal protections on top of each other. You know, like an LLC is one type of protection, then your trademark is for something else. A copyright would be for something else. Like maybe insurance is another layer of like protection. Contracts are another one. So it's kind of like you just want to have as much protection as you can. So you're just really stacking these different legal aspects.
Gotcha. And clearly, if you're not an attorney, you should probably hire someone to do it, because you don't know what the heck you're doing. And YouTube University is very good, but how much I love stories. Like I love stories because that's how I learn, right? So what is the worst case scenario you've heard of somebody who decided to go at it on their own and try to trademark, and how much it cost them?
Yeah. So definitely having to fight for your brand would be the like well, the worst case would really be potentially using something, not filing for it, someone else getting there first, and then, maybe they start with the cease and desist, but then they end up suing you, and they can actually, if they get the trademark and you don't have it, they can sue you for the profits they made, that the profits you made using their trademarked brand. So there was a girl on TikTok, Pokey Princess is the name she went by, and Pokemon, I'm thinking like who owns that? I can't think of the name of it. Is it like Nintendo or someone? Whatever the larger company name is, did not like that, and they ended up suing her for all of the profits she made using the Pokey Princess brand because she didn't change it. And they said that it was too close because I think she was doing something related to like Pokemon. So that's kind of like the worst case, that you make money off something and then you have to not only spend on like legal fees, need a whole new brand, but you've also been sued for all of the money you've made. So now you're in the negatives.
That's sad.
Yeah, it is.
So if somebody was looking to say, okay, they answered the 3 questions that came up that, yeah, I should probably trademark. What, because there's a ton of lawyers out there. And so who should you choose? Like, what should you look for in an attorney?
Yeah, so I usually recommend looking for someone that does trademarks, either like exclusively or like that's one of their, main things. I find like sometimes when I have a lot of clients that have come to me from larger firms because the attorneys tend to, do a little bit of a lot of areas of law. And so they're not really like, as familiar with it. So they might have missed something because it's all these little specific things that like can cause your application to get rejected. And then a lot of it is not fixable except for refiling again. So I would look for someone that either primarily does trademarks or does, like trademarks, copyright contracts, like a couple of the business topics, but not like everything under the sun. And then, you can always ask them questions like about the process, about trademarks they filed, or like how many they filed, or how long they've been doing it. Because, it does take over a year just to get your first one fully registered. So it takes a while. So, asking as many questions as you can and making sure that they're going to explain the process and also explain any fees later on, because the USPTO has fees like if you file an application but you're not yet in use, you just want to hold the name, there's still another filing fee that's going to come on later down the road. That's $100 per class. Or if you have to extend it, you're not ready to show use yet, then it's $125 per class. So those can really add up. And sometimes I find people that are like, oh, I had no idea about, the additional things or like how long it took or certain things. So I think asking about the process, the fees, everything laid out, is really like the best way to go.
Wow. So much information, and that's why you hire the expert, right?
Yes.
And I do agree. I mean, with anything, if you don't specialize in that, and you haven't tried it, you haven't done it, it is hard to be able to know everything that you're doing. Like, I'm a real estate agent, and if you ask me commercial, I've done a few commercial deals, but I absolutely I go to commercial people as well to ask for more advice as I do it. So yeah, you need a specialized person.
Yeah, definitely.
So it takes a long time to get through. And then if you do something wrong, you can't just fix the application. You have to refile. And
so sometimes you can fix it, but certain things you can't. Like if you didn't include something in your description of goods and services, and the thing you wanted to include would like add to it, you're not like you can delete something if you're like, oh, I'm actually not going to sell that, so let me just delete hats from there. Like you can do that, but you can't add in hats if you forgot to put it in. So you'd have to refile. And then, so like things like that, or, if you change, like if you didn't put like, let's say you use like an ampersand, but you really wanted it to be like an end, like maybe they would let you change that, but maybe not. Because, it's basically like, is that a material change? So there's just a lot of things where like maybe
It's ridiculous.
and so yeah, and they're very specific with like the way that they want you to word things for the goods and service description. So it's like they're so, I usually say to my clients, I'm like, they're so nitpicky because my client will say like, oh, I want to do this, this, and this. And then they'll see me word it in this way that's like educational services, namely providing live and online courses in the field of blah, 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 and educational materials in connection therewith or whatever. And it's like, that's just the way that like they want things worded. So, they're so particular. So that's something that, you need to know when you're filing so you don't have to like redo it.
Wow. I can't get past the hat thing. So if you decide to do hats, then you have to refile the whole thing. And so then here's my next question is you're here, somebody else is here, and you go back here, which means they win?
Possibly. So that's where it's not. So that's really where it would be like an examiner would see like, so if yours was in front of them initially and then someone else applied and then you wanted to add that, whether theirs, the next one got through or not would be like, how similar are the goods and services? So like if your initial one had like, let's say like scarves and pants and, winter like gear and something, and then someone else applied for like hats, or like winter hats, like would they get approved? It depends how similar, like, because they might get, or I would assume they'd probably get a refusal right away if it was very similar in like the name or identical name. And then they would basically have the chance to submit an argument to try to differentiate the brands. So, there's maybe a chance that they could get through, but maybe not. So maybe just because, so basically it's like how close is what came behind you and what you're maybe going to apply for later on. If you're wanting to add on something that's like not as related to what you already have the trademark for, it might be harder. But if it's going to be something, like let's say you're already registered for like photography, it might be easier if you want to like apply for like videography services or something. Whereas like it would be more difficult if now you want to add on like a podcast because that's gonna, be pretty different. So my favorite answer and like the what I say the most of the time is like it depends.
Yeah. And that's my favorite answer to ask any one of my real estate clients. They're like, Charisse, what about, let's say it together. It depends.
Yeah, exactly.
Because no case is the same. I mean,
Exactly.
everyone's different.
Mm-hmm.
So if you are like, say that I do have a series of books that I want to do, but yet I also want to start doing what's the word I'm looking for? Not conferences or workshops or things like that. So I would have to make sure that I really think through everything and decide how far do I want to go with this before I file. Is that what you're saying?
A lot of it, yes. So usually like when my clients come to me and before I do the search, I send them an intake form and I tell them in that to put all their goods and services, even if it's not what they're doing now, but they think they might want to do even in the future. That way I can at least do the search for those goods and services. And then after that, that's where we really narrow down like, okay, what is like priority realistically? Because you don't want to apply for something that you are going to, maybe you want to do in like 5 years or even like 3 years, because then when you get to that period where you're going to have to show use, you get 6 months to do that. And then first we have that like 9 to 10 month waiting period. Then it gets reviewed and everything. And then then it goes through publication where it's 30 days where anyone can oppose if they think you're infringing. Usually it's like if you try to file something that's similar to like a big brand, Nike, Disney, something like that. And then you get that notice where, okay, now you have 6 months. So it's already, you're like a year into the process at that point, but then you have 6 months. So if you're not going to be in use by the end of those 6 months, then you're going to be paying those extension fees, 125 per class. So, maybe one extension fee is like, if you think, okay, I can be in use in that 6 months, or maybe have to pay one extension fee. But if you're going to be paying more than that, it might not be worth it just because those are going to rack up those fees versus like the initial file, just filing in the future when you want to do that. So that's where it's really like weighing what it is and how soon you think you want to do something. So yeah, it's a lot of thought about like what you're doing now, what you're planning to do in the next 1 to 2 years versus what you're planning to do in the next, further out than that. So a lot of like thinking about that, and then also weighing the filing fees of all of that, depending on what class all of these things fall into.
Absolutely. Well, it's a lot of information. So if somebody wanted to get a hold of you, how do they find you?
Yeah, so you can either message me on Instagram at lawyer Kelli with an I _. You can also go to my website, kellijonslaw.com, Kelli with an I, and you can find other contact information and information about everything else there as well.
Great. Well, Kelli, thank you so much for coming on. Fantastic information. And
Yeah,
Unbreakable Moms, if you are thinking about trademarking, I highly recommend that you schedule a call with Kelli to make sure that you know what you're doing and you don't waste any time or money. So go make it a great day. Thank you so much. Beautiful moms, remember, you are unbreakable. Keep illuminating the world with your strength, pursuing your dreams, and reveling in the splendor of motherhood. This is Charisse Walker, bidding you farewell for now. Stay tuned for more empowering conversations on the next episode of the Unbreakable Mompreneurs podcast. Until then, keep shining bright. Signing off with love, Charisse Walker.